everyone. Welcome to the IOP's first speaker event of the year, Trump's Legal Woes. My name is Maggie Wells, and I'm a 3L at the law school, and I'm here to introduce our panelists. We're joined today by Ty Cobb, Jennifer Taub, William Baude, and Heidi Heitkamp. Mr. Cobb is a lawyer and served as a member of Trump's legal team from July 2017 to May 2018, where he was appointed to manage the Mueller investigation into Russian interference in the election. Prior to joining the White House, Mr. Cobb was a partner at Hogan Lovells in D.C., where he specialized in white-collar crime and securities enforcement. Mr. Cobb also previously worked as an assistant U.S. attorney in Maryland. Professor Taub is a legal scholar and professor at Western New England University Law School. She is an expert on white-collar crime and financial regulation. In 2020, Professor Taub published her book, Dirty Money: The Shocking Injustice and Unseen Cost of White-Collar Crime. Professor Taub is also an expert in the 2008 financial crisis. Her book, Other People's Houses, was one of the Massachusetts Center of the Book 2015 nonfiction finalists. She has also testified as an expert in front of several congressional committees on financial regulation and the 2008 crisis. Professor Baude is the Harry Calvin Jr. Professor of Law at the University of Chicago Law School and currently my conflict of laws professor. Professor Baude is an expert in constitutional law. He is the founder and faculty director of the University of Chicago's Constitutional Law Institute, and he is the co-editor of 2 textbooks, one on the Constitution and one on federal courts. This year, Professor Baude co-authored a forthcoming article, The Sweep and Force of Section 3, that argues the 14th Amendment disqualifies President Trump from holding public office in the future. Professor Baude also hosts a legal podcast called Dissenting Opinions. Finally, this event will be moderated by Ms. Heidi Heitkamp. She is the director of the University of Chicago's Institute of Politics and served in the U.S. Senate representing North Dakota from 2013 to 2019. She has a law degree from Lewis and Clark College and served as the Attorney General of North Dakota from 1992 to 2000. Before we begin, please silence your cell phones. This event includes a Q&A. There will be a stationary microphone in the audience for questions. UChicago students get priority in asking the first 3 questions. The IOP Speaker Series also has some more fun upcoming events. On October 5th, the IOP is hosting a panel on the 2024 election with David Axelrod at the Quad Club. And on October 10th, the IOP is welcoming Illinois Governor J.B. Pritzker to talk about progressive governorship. Check the IOP website for more information on future events. Please join me in welcoming Mr. Cobb, Professor Taub, Professor Baude, and Ms. Heitkamp.
Thank you. Thank you. I think, does she get extra credit points for giving you a little shout out there?
Well done.
First off, before we begin, I want to say one of the things that has really amazed me about being the new director of the IOP is the generosity of the people who come here to speak to our students. And you can see by these resumes that these are incredibly talented people with a lot of things that they could be doing, but yet they come here because it is so important to have a meaningful dialogue about the issues of the day. And so I want to thank all of our panelists for agreeing to come to the IOP, and they should thank me because they get to be in the shade. My apologies to all of you back there. We should be handing out umbrellas as we look forward, but we were grateful for this beautiful day. You can't wake up in the morning and not get 5 bits of news, right, about what's happening with, as the media calls it, Trump's legal woes. Where is all of this headed? And so what we had hoped with this program is to basically give you a sense of kind of where are these challenges, legal challenges, what do they mean for the Constitution and for our democracy and for the rule of law? And then, importantly, what do they mean for this next political cycle that we're going into? And so the first thing that I would ask is, and probably to you, Jennifer, that we, Professor, I guess there's too many professors up here, that we kind of are looking at the news of the day, whether it is Trump showing up at his the civil suit that the Attorney General of New York brought against the Trump organizations, whether it is Eastman now being denied cert on his attorney-client privilege protection that he was asserting. Can you give us a sense of where we are with all of this litigation and what these good folks could see in the next maybe couple months that would be significant?
Well, first of all, thank you, everyone here, for coming to this event, and the folks at IOP for inviting us. And Senator, you can call me Jennifer if I can call you Heidi. And
You got it.
Then we're good. If you're confused, you can be forgiven. I follow this stuff, full time, and it is so chaotic that my spreadsheets have spreadsheets at this point. If you think about it, most of what Donald Trump is facing now, the civil and criminal cases, came into being in the last year, in less than a year. And so to track it and to make sense of it, I would just say the way I look at it is there are 2 major civil cases he is still facing, and there are 4 major criminal cases, some of which we're going to start, today. There's a case happening right now, as you mentioned, in Manhattan. And then there's another defamation case involving E. Jean Carroll that's in January. And then we've got the 4 criminal cases. And for me, the way I think I would think of it is pay attention to what Donald Trump is doing, not necessarily what he's saying, and he is in a courtroom today. And this is therefore, in my view, the most important case for him because it threatens his livelihood and for his entire life, especially adult life. His whole identity is wrapped around his image of being a billionaire and his actual access to what wealth affords for him, which has been essentially impunity, like many other wealthy, white, well-connected men, not having the laws apply to him. Now, all of a sudden, that's coming down on him, and he can hire as many lawyers as he wants and try to delay the criminal cases, and maybe those drag out past the election, and maybe he has to serve some kind of time at some point. But none of that would pale in comparison to him losing control of his businesses, losing control of his properties, and losing control of his money. So I would focus on what I always focus on, which is follow the money. Donald's doing that. That's the case I have my eyes on.
So, Ty, I want you to kind of respond to that because those of us who have been prosecutors, who have been in that world would say there's never a civil case that is as dangerous to someone as a criminal case. What's your reaction to what Jennifer just talked about?
I think Jennifer's absolutely right. First of all, thank you all for being here. I think Jennifer's absolutely right about the danger of today's case. I don't think the other civil case is consequential. That's just about money. Another defamation case, he's already been convicted of defamation, and then he managed to do it again to the same individual. But I think the sweeping nature of the summary judgment motion that took away certificates to do business for some of his key businesses and some of his key properties does shake the empire a little bit. And what keeps Trump as a magnet to many of his followers is his business success and acumen, which is being pilloried right now and shredded, I think, and will be further shredded today. Also, his money helps. And he could lose a lot of money. He could be in bankruptcy again, which would, I think, only add to the double-digit bankruptcies that he has historically had. So I do think that's important. On the other hand, I think the key cases are the 2 federal cases, the charges in D.C. relating to the efforts to stay in power, and the charges in Mar-a-Lago in Florida with regard to the classified documents, the efforts to conceal it, and the obstruction of justice issues that he faces there. I think those are cases in which he could easily be sentenced to incarceration. And given my experience with the guidelines, a judge is going to have to depart pretty aggressively under difficult circumstances if Trump's convicted to keep him out of jail.
Yeah, that's one of the issues that we're going to explore over the next hour before we go to Q&A, which is, when do you draw the line on the rule of law? Like everybody's equal under the rule of law, but are they really? And that really is a good transition point, I think, to you, Professor, in terms of making this decision to issue a pretty aggressive opinion about the consequences, not just even if there's a conviction, but the consequences today of some of the indictments and some of the behavior. Can you give us what's the books that they do in law school? Cliff Notes. What is it?
A horn book.
Oh, the horn book. Can you give us a horn book kind of explanation of how you see where he is right now legally?
Sure. So one other set of legal woes come from, in a sense, the Constitution itself. So after the Civil War, the 14th Amendment was enacted. It contains a provision that says that anybody who held office and swore an oath to the Constitution and then engages in insurrection or rebellion can't hold office again unless Congress gives them amnesty because of the concern about letting people sort of back into power right after they've betrayed the constitutional system. And there are now a series of lawsuits in Colorado, Minnesota, Michigan. Those are probably the most important ones. Some of them not formally against President Trump, but against the electoral system, saying to the Secretary of State, just as you can't have somebody on the ballot who's under the age of 35, just as you can't have a president on the ballot who's already served 2 terms as president, you can't have Donald Trump on the ballot because he engaged in an insurrection after having taken an oath to the Constitution. And so those cases are pending as well, and in a way just pose a separate, maybe equally important question, which is, whether he's a criminal or not, whether he goes to jail or not, whether he gets to keep his money or not, can he have the country back? Can he be entrusted with the office of president again or not?
Well, I want to follow up with you just for a minute because obviously we rely on trials to determine facts, but yet you've been willing to say that probably might not be qualified today, even though we haven't seen a criminal trial in the January 6th indictments. Why are you willing to kind of stick your neck out there?
Sure. So the incident obviously is the January 6th insurrection against the Capitol, and a huge amount of what happened is public record. A huge amount of it has happened. It's on the internet, and then we had extensive findings and research from the House Committee on January 6th. So part of what I've written is based on what we know, it seems like Donald Trump engaged in the insurrection on January 6th. Now, the way this works is that, in theory, Trump does have the right to come forward with exculpatory evidence. So if he wanted to volunteer to take the stand in Minnesota and explain himself, I think he'd be allowed to. This actually happened to Marjorie Taylor Greene in Georgia a couple years ago. She, too, there were proceedings about January 6th, and the Georgia election officials said, there's a serious enough question here, we'd like to hear from you. And so she sat for 3 hours of depositions and eventually convinced a hearing officer that she had nothing to do with January 6th, that she was horrified by it and wasn't a part of what happened. I think Donald Trump would have the right to do that.
Well, it's very interesting, and so I think you want to watch Michigan, you want to watch Minnesota, and you want to watch Colorado. And these will be, we can talk about the political implications of that kind of decision-making, but they definitely are very serious about pursuing a dialogue about qualification on the ballot. One of the issues that has been, for those of us who think about politics as a debate between ideas. We obviously now have had this huge surge of dialogue around Donald Trump's legal woes, and not, what should we do about China? What should we do about the debt and deficit? We spend a lot of political time. We spend a lot of time in the 24-hour news cycle and in the major news cycles talking about the Trump's legal woes and what that means. Jennifer, if you could just, we were laughing. I said I tried to create a spreadsheet kind of with dates, and Jennifer says she has one in her head that will tell you all the dates that are coming up. But if you could tell folks here, in the next 2 months, what dates should they be looking at, and what's the consequences of those behaviors? Well, and give us an idea of whether you think any of this will be resolved in the near term.
Thank you. Yeah, I shouldn't have been boasting in the green room about my memory. But yeah, so as we know, today we have now in Manhattan the case of the Attorney General for New York bringing under the remaining non-resolved charges in that civil complaint as well as damages involving inflating assets. So that's happening now. We also have coming up on October 23rd, the defendants in the Fulton County RICO case, racketeering case involving the events leading up to and through and beyond the insurrection in January 6th. We have Ken Chesborough and I think Sidney Powell have asked. They have not waived their speedy trial right under Georgia law, so that trial is scheduled to begin October 23rd. And then, speaking of Minnesota, So speaking of Minnesota, there is a hearing date at the Supreme Court of in Minnesota for a month from today, November 2nd. And this is one of the cases Professor Baude mentioned. Full disclosure, I'm on the board of on the legal advisory board of an organization called Free Speech for People, and they're bringing that case on behalf of, I believe it's 7 or 8 voters in Minnesota. And that case has gone, it's different than some of the others. That case has gone right up for a hearing at the Minnesota Supreme Court because they want the Secretary of State there to do what he is refusing to do, which is to make a determination as to Donald Trump's eligibility to appear both on the primary and general election ballot. And I just want to add one more thing to that to tie it into the Michigan, which is in both of those cases, both brought in part by Free Speech for People, the lead lawyer Ron Fine there. In both those cases, it's a blend of the constitutional question and state law, because in both in Minnesota and in Michigan, there is a state statute on the books, they're sort of similar, that requires the Secretary of State to make a determination, I should say, they have the authority and the obligation to indicate who has the right to be on the ballot. As Professor Baude said, 22nd Amendment is out there. And if someone, if let's say, Bill Clinton wanted to be on the ballot, it would be ridiculous to think that he would be put on the ballot and we would just wait to see if the voters decided. So it's the same idea, eligibility based on age, based on other constitutional requirements. That determination has to be made. So the hope is with that hearing that we'll hear more about that there. And in Michigan, the case is different. It's been brought in the Michigan Court of Claims, similar to the case in Georgia and the case with Madison Cawthorn. I'm forgetting which state he's from, where in those instances, the state courts, even though those cases disposition was Marjorie Taylor Greene, the court decided, no, we don't think you engage in insurrection, and it became moot with Madison Cawthorn because he wasn't elected. There were some important precedents established in those cases, and I think we need to watch this in for November, which is that, one, yes, a court can adjudicate these questions. 2, that it's not a constitutional violation to take someone off the ballot if they have been an insurrectionist. And 3, one of the more important ones that came up in the Cawthorn case is that a lower court judge was overruled when he tried to say that the 1878 Act, which gave amnesty to some insurrectionists, somehow would trump Section 3 of the 14th Amendment. So that's kind of been wiped away. And so I'm hoping in these hearings that Donald Trump and the voters get an opportunity.
It is Chicago.
Get an opportunity to have, that hearing in court, because even if, and I totally agree with the sweeping claims that Professor Baude and his co-author make in the article about Section 3 of the 14th Amendment, even if it is self-effectuating, the bottom line is someone has to print the ballots, and right now there isn't a Secretary of State in this country who is going to take him off the ballot unless a court orders them to do so.
I think that's absolutely right. And think about these states. Theoretically, Donald Trump could get elected president and not appear on the ballot in Minnesota, Michigan, or Colorado. And so it creates a really interesting state-by-state dynamic. Mr. Cobb, you probably know Donald Trump. I've spent some time with former president, but you know him much better than all of us. I'm wondering if you could give us some insights on not trying to predict behavior, because this is somebody it's very difficult to predict behavior. But how is the former president's legal response been so far in your judgment? And what do you expect to see, especially in the federal cases, with the federal indictment, the Mar-a-Lago defense, what I call the records defense or classified documents defense, and what do you expect will be the defense in the January 6th?
So thank you so much, Senator. I think that the legal response so far is best characterized as chaotic. He has teams of lawyers. The members of those teams change periodically. They have not enjoyed much success anywhere. They got crushed in the Jean Carroll case. They're not doing well in front of Judge Chutkan in D.C., who, full disclosure, was once an associate of mine. And they're not doing well even in front of the judge that they like in Florida, Judge Cannon, who set a much earlier trial date than the president and his team had hoped she would. Now, she may move that. She hasn't moved that case at great speed. As a result, she is the only judicial officer in Trump's orbit that he hasn't referred to as deranged. I think on his hand he has a tattoo that says deranged, so that if he ever gets stuck, he knows exactly what to say at this stage of the game. Trump is. You see a lot of articles that he's afraid of going to jail. That's not true. Trump doesn't look at the world. He doesn't have any fear. He's a complete narcissist, and he believes that he's righteous. That people who don't believe in him are traitors. That he will prevail at some point, and that if he doesn't prevail, he can exhort people to put pressure on congressmen, senators, lawyers, judges, the populace, and force them into action that will, heal them in his wake. He does not. He does not have a strategy. He doesn't have a defense in connection with either the Mar-a-Lago charges or the January or the D.C. charges. One of the questions I always ask when I'm on a variety of panels in the media or elsewhere, when somebody talks about how Trump's going to make a vigorous attempt at trial, my question is always, well, tell me who's his first witness. What are the documents that he's going to introduce? Because there really are none that defend him in connection with those serious charges. In Mar-a-Lago, the evidence is just overwhelming. They've got the classified records. They've got him actually showing the classified records improperly to other people. One of the women who is senior on his current team is a witness against him in that action. So as to the two federal charges, he really has no defense. Those are going to be really real battles. And what they turn on is whether or not he gets elected president. Because if he gets elected president, he'll immediately appoint a lackey to head the Justice Department and tell him to dismiss the charges or withdraw from the cases, dismiss the appeals, whatever is required. And that'll be done, and that'll be the end of the federal case. He doesn't have to, there's a lot of wasted time and energy that goes into can he pardon himself. He doesn't have to do that. He can direct the Justice Department to just dismiss those charges and withdraw from those cases. So I do think his strategy, to the extent he has a legal strategy, is to win the presidency. That doesn't insulate him in Georgia. I'm sorry, and because Georgia is a state proceeding, there will be an issue as to whether that proceeding can proceed if he does get elected during the 4 years that he would have to serve. The rule at the Justice Department, which, by the way, is only a rule. There's no statute and nothing in the Constitution that suggests that it's required. But the Justice Department rule is that you cannot prosecute a sitting president. That has never been extended to the states because the only time anybody's ever asked for advice on it is internally within the Justice Department. So that's a long answer to what was a pretty good question, but the simple roll up is he doesn't really have a strategy. He's got some good lawyers, who seem to be fighting among themselves. That's not good, and it's clear that there is no single lawyer in charge, which is a disastrous mistake. You need a leader. You need somebody coordinating these things that has a common plan and can make sure that nobody speaks out of school. Instead, he's got multiple teams, all of whom seem to speak at will.
Yeah. Those of us who have some familiarity with the former president knows he thinks he does well in chaos. And those of us who have law degrees think that's the worst kind of legal strategy that anyone could ever devise for themselves. Chaos does not frequently translate to a situation where you have a theory of your case. If the theory of your case is chaos, that may be problematic. But I want to turn to away from personality and just take this to a level of constitutional challenge, Professor. We have a situation where norms where we believed that could never happen. Guess what? There was never a rule. There was never a statute. There was a norm. There was a kind of commitment that people in politics had to the peaceful transition of power and making the glorious speech like Senator McCain did the night that Barack Obama defeated Senator McCain, standing up, talking about our democracy. So looking at the gaps that we now see as a result of these challenges, have you thought, or has any of your colleagues thought at that brilliant law school that we have over here at the University of Chicago about kind of changes that need to be made to see a firmer kind of footing for our democracy going forward?
Yeah, that's a great question. That's a great question as well. So I think there is a sort of technical answer, which is yes, and a global answer, which is kind of no. So there are things like...
How do you grade him for that?
The way in which Congress is supposed to open and count the votes on January 6th in joint session, right, is itself kind of confusing, is governed by an old statute that dates from the 1880s, the Electoral Count Act. That was reformed by bipartisan legislation. It sort of didn't get a lot of news because the only way to make major legal reforms was for everybody to just quietly agree to improve the rules and not make a thing out of it. We now have something called the Electoral Count Reform Act that restructures and clarifies a lot of things about the authority of the vice president, the ability of one senator to grandstand by making lots of objections, those kinds of things. That's a great improvement. There are also sort of lots of little election security changes like that, the way we deal with ballot security, the way we can prove afterwards that there's no fraud. Like a lot of those things have and will continue to get better. But there is this global point that you mentioned that still, for all of the laws we have, like a lot of the system relies on norms, and it's not quite a norm, but relies on the idea that hundreds of millions of people in this country will accept the results of the election, even if their side loses, as long as it's done in the right way. That, it turns out to be something that you can't just take for granted, right? You can't just wish that into existence if it's not there. And when we look around the world, this is what I've learned from many of my colleagues, there are lots of countries where that doesn't happen, where they can't take that for granted, where this is a real recurring problem. I remember talking to a visiting judge from another country that had come to study some American constitutional law. And the question he had a specific question that he thought American constitutional law experts could help him answer. He said, what is it in your Constitution that says that when the president goes abroad on official business, the vice president is not allowed to declare himself president and stop the president from coming back into the country? This is apparently a problem they'd faced in his country.
And you thought you had many things to keep you up at night. Add this to the list.
And he knew that didn't happen here. And he knew we had a great constitution. And so he thought, he started with sort of the naive question, is there something somewhere in there? Like in Article 2, is there some clause I missed that says that can't happen here? Right? And it probably would be unconstitutional for it to happen here, but it's not because there's a clause that says the no coups clause. And if there was a no coups clause, that is not what would stop the coups, right? That's the sort of more global problem we're facing. And that's the problem faced even by, for instance, the current litigation about insurrection and eligibility. That's kind of a no coups clause. Like, it's some specific rules of what happens if you commit certain kinds of coups. It's there. Courts are working on it. Maybe we'll end up taking it seriously in the end. But there's nothing in the Constitution that forces that to happen, right?
So this is going to be a question for the entire panel because it's something I think about as a lawyer, as somebody who has dedicated their life to public service. I think about all the things that I thought could never happen that I have watched over the last 5-6 years happen. And why is it that the public has a real cynicism and distrust of the rule of law and the advancement of litigation today that seems logical to all of us who have served as prosecutors, who have served as lawyers? It's the natural consequence of certain behaviors. You would expect there would be litigation, but yet the public, a great percentage of the public believes that this is politically motivated, not motivated by the facts. And so my question would be, how do we reestablish a rule of law kind of attitude within the American public, that it's not pick or choose, that there is in fact a process that is being carried out that is essential to preserving the democracy today? We'll start with you, Jennifer. Like, how do we change the hearts and minds of the American public that is so cynical about this litigation?
This is one of the hardest questions I've ever been asked. And so I'll try to break it apart and say, let's start with the premise that there is some portion, might be the majority, might be a little more than that, who's cynical. And I would say I can understand why they would be. And then I'll talk about how maybe to correct it, which is to say the book that was mentioned that I wrote called Big Dirty Money talks about in the preface how someone like Donald John Trump, if he had actually been held accountable over the last 50 years of his career for the many unlawful actions that he took, instead of settling them civilly with various agencies, and I can make a list of them, but just trust me, it's decade after decade. If he'd actually been held accountable earlier, he would have spent time in federal prison instead of the Oval Office. And so I think there's two kinds of cynicism. There's some like, why does it take so long, even if no one is above the law? Why does it take so long for the legal system to catch up with someone like him? So there's that kind of cynicism. And then there's the concern from the other side, which is, and it's married to this, we let him get away with all this stuff all these years, and now suddenly the hammer's coming down. Is it only because he's running for office? And I guess what I would say is two things. Maybe not. I mean, when there's this expression that accountants have about following the accounting rules for your taxes. I don't know if you've heard of this. Pigs get fat, but hogs get slaughtered. If you want to brazenly, no one should be breaking the law, but if you're going to brazenly, flagrantly break the law and you're in a position of public trust, then yes, the law is going to come after you. And it has nothing to do, I think, with your political party. I mean, you can look at Senator Menendez as one example. Prosecutors have to make choices. Now, in terms of the public perception of this, people get their news now from YouTube or TikTok. And I'm not criticizing those venues. I'm just pointing that out. Or, the website formerly known as Twitter. And that's filtered through our own kind of, the stuff is going to be fed to you that reinforces what you already think. And so I'm not entirely sure how to reach people who already, there's some group that will always believe that Donald Trump is a victim. But I do think with some of these hearings that will be televised, that could change things. I think with witnesses like Cassidy Hutchinson, I just read her book that came out last week. I think people like her are convincing witnesses. And I think that the only thing that can help is for people to look and see people that look like them, think like them, have no reason to turn against somebody was part of his political party. When they speak out, I think that could possibly help. But we're never going to get 100%, right? There's still people who think that Nixon was, railroaded into resigning.
Yeah.
So I agree full-throatedly with what Professor Taub just said. I do think that the elephant in the room that has to be acknowledged is the visceral nature of the media at this stage of the game. As Professor Taub pointed out, no matter where you go, your information is pretty heavily filtered, and there's a conscious bias. Whether it's MSNBC, which makes money from its advertisers to support its message, or Fox, who does the same thing, spouting opposite theories and views and philosophies. I think that's something. And I think that Professor Baude has commented on this in some of his writings, which is, the Constitution was written at a time where it's highly unlikely that the founders ever contemplated, that the media would have the enormous power that they have now in terms of shaping minds. Remember, this is a republic founded on the theory of an informed electorate. It's hard to be informed these days. You really have to dig for your information. So I think this is a very complicated time. I think it's going to take some healers. We haven't been faced with great choices recently in terms of selections of our leaders, and we haven't seen many new leaders come forward in the past decade who give us hope and inspiration and enthuse the country about what we can do when we're not divided. And I think it's important that that happens soon, or the abyss is going to continue to grow. So I think with regard to the issue of how do we get back to normal, that we're a long way from normal, and it's going to be a 20-year slog at best to get back to chugging along in the way that we used to.
Yeah. Or we never see a reset to normal.
Or we never see it.
So, Professor.
Yeah, so I think the question of how do you get people to accept law that they don't like, right, is one of the questions that, it's one of the questions that the legal system and law school obviously grapples with all the time, right? Like, how do you make the law produce legitimacy? And so there is one theory is the kind of like punish them into submission theory, right? Is like you just apply the law, if anything, extra hard to the people who currently doubt the legitimacy of the system, because you've got to destroy it. You sometimes hear this idea of like if we just eliminate MAGAism or Trumpism from politics, like we cure it somehow, then we can go back to normal.
If I can just interrupt, isn't this really what a lot of the public is saying about the January 6th convictions? Like, that wasn't just, we want you to throw the book at these folks because we want to scare people into submission.
Right. And you saw this. This is one view of how to deal with the South after the Civil War. This is one major theory. Now, a competing theory is something sort of the opposite. It's like, let's go extra easy on them because, they'll get really mad if we apply the law aggressively, or even if we apply the law neutrally. So one version of this we hear is, Donald Trump's supporters will riot if he is convicted or kicked off the ballot. And so even if that's technically right, let's not do that because it would be bad to provoke a riot. That's another theory. Obviously I tend to go for the third theory, which is, you just kind of apply the law the same to everybody, and that's not always going to work. People are sometimes going to get mad about it, but it beats trying to tilt the scales against them, and it beats trying to tilt the scales in favor of them. I once worked for a man who said the job of a judge is just to be an umpire calling balls and strikes. And everybody made fun of him for that, but I don't think anybody's come up with a better theory for what the job of the legal system is. I think one problem is, and this is the most depressing thing maybe, we have this hope that this moment is unusual and it's going to end somehow. Like we're going to proceed to some promised land.
The fever will break.
Yeah, or where everybody agrees again, or at least everybody we disagree with agrees to accept us as legitimate, is what we really care about, right? But this is not that unusual in that sense. Like, unfortunately, our country has a long history of serious tumult, rebellion, before the Civil War, after the Civil War. We mentioned Nixon. We mentioned, so the real question is, how do we run a country and a society given how strongly we disagree?
So I'm going to pivot and maybe go to an area that I hadn't thought about until we had started this conversation, which is your former boss, clerk for Chief Justice Roberts, clearly the head of the court as the Chief Justice. But one of the reasons why the public is more informed about what happened on January 6th, in my opinion, is really the televised January 6th committee hearings, where they could see in real time the dialogue and the narrative. One of the challenges that we have in public acceptance is that so much of this will be in a courtroom where there is no camera, where there is no public exposure to the kind of day-to-day evaluation. That's not true in Georgia or any of the state courts, because state courts are much more liberal about allowing cameras into court proceedings. So I'm going to turn to you, Professor, as a former clerk of the U.S. Supreme Court. Would you argue with your former boss that this is such a unique set of circumstances that we need to bring a camera into the court so the public that wants to watch these proceedings has those proceedings available to them?
Definitely not. I mean, so again, there is a good reason you follow the rules and you don't start making exceptions just because you have a high-profile case. I do also think the record of things like cameras is complicated. You know, I watched the O.J. Simpson trial, a lot of it when I was growing up.
You must have been a baby.
I was young. I did not understand what was going on. I don't know that the net effect of the O.J. Simpson trial was to increase like the legitimacy of the verdict in the public's eyes. I mean, we all grew informed. Like, it was a very valuable lesson. And I mean, this is maybe too personal, but I think people debate like between the Supreme Court, which doesn't have cameras in the courtroom, and Congress, which has cameras on the floor. People debate which of those has become sort of like the better forum for deliberation and debate. Obviously, there's a benefit having cameras in terms of transparency, but there's also a cost in terms of turning things that might still be a real opportunity for candid dialogue into slightly more performative dialogue, and people worry about that.
So I'm going to amend my request. So you can listen to a Supreme Court hearing. You just can't watch one. Is that true for the federal courts? Can you listen in real time to a court proceeding?
Not typically.
So how about if we just do auditory?
That'd be better.
Okay.
That'd be better.
So, I mean, the premise of my question is that when things are transparent, when you can, in fact, watch the proceeding, you feel like you have a knowledge that you don't have reading a newspaper or watching the talking heads, and we've all been talking heads, right, on television shows. Do you think there should be an exception in these cases, given the gravity of the risk to democracy of people not accepting the outcome, one way or the other, quite honestly? Do you think there should be an exception to the cameras in the court? We'll start with Ty.
I don't. Now, I say that as somebody who, has tried over 100 cases, and also I've also handled, a number of witnesses and companies in front of congressional hearings. The congressional hearings, which we can see, as you know, they turn into 5-minute speeches without a question, at the end of which the witness doesn't really know what to do. So it's not it really is art, performative art. And using O.J. Simpson as a example, I think cameras in the courtroom threaten and often have, and there are states where it's allowed, but cameras in the courtroom threaten to turn a lot of serious judicial officers, thoughtful people, into Judge Itos, where they insist on making it about themselves, and I think that's the last thing you want. I mean, so I do think that cameras in the courtroom, threaten the direct presentation and the mechanisms through which justice is supposed to work. But I also understand the need for public acceptance. I think that public acceptance could be addressed a lot by participants being interviewed in a non ideological context, but that doesn't seem to be available anymore.
So I often equivocate on this, and I think where I land is these days is closer to where you both are, which is I don't think cameras in the courtroom are necessary, but what I do think would be helpful and my new reason is beyond what you all are saying. I'm actually, besides the sort of circus atmosphere it can create if a judge doesn't know how to deal with that, you also have witnesses who might be uncomfortable testifying, jurors who are worried even if the camera's not on them. But now with the advent of AI, it's very easy to do deep fakes. And if any video is available, people could just manipulate that and say this happened. If we all know there was no video available, then we know that didn't exist. That seems a little bit counterintuitive. But what I do think is absolutely essential, and I think it's completely outrageous that we cannot have free transcripts. And I understand that the people who are court reporters have businesses, and that's why they want to charge for them. But it's unacceptable the public cannot, for free, read a transcript of some of these important cases. So that should be resolved, and I think, the Chief Justice should figure out how to do that. And I don't know if it should be an exception for cases like this, but we've got to, pay the court reporters somehow, some way, in these cases. We need to be able to read those transcripts as a public.
Well, when you look at kind of where we are right now with the Supreme Court, it was, I used to laugh, I had a colleague who would say the favorability rating of United States Congress was 9%, and he couldn't figure out who those people were. And we know that we have very low favorabilities of the president historically. But think about this. We have always had very high ratings for the American judiciary. That has changed. How has that kind of changed in terms of people's attitude about the judiciary? How has that affected kind of the consequences of this litigation? And we hate to pick on you, Professor, but how do you see the intersection of the crisis of confidence, if I can, and that's probably an exaggerated term, along with this need that if there ever was a time when the American public accepted the legitimacy of our judiciary and in our democracy, it's right now?
So I feel like this is one of those places where the short term and the long term, come to roost. I think for a long time, many people had the view, well, the courts are the most legitimate. So if we can win the courts, we being the right or the left or both, if we can win the courts, that'll be the most enduring because that's really legitimate and, nobody will question that. It's one thing if we pass a law, but if we get the Supreme Court to say it, that'll really stick. And the thing is, the more you politicize the Supreme Court, the more you use up that institutional credibility, right? So in the short run, I totally understand why everybody wants to do that. Because if that's currently the most powerful in some sense, then you want to have that power. But in the long run, there will come a time when you just wish there was some neutral body we could all agree on at the things we really, are mad at each other over.
Before we move on to Ty, it's time if you have questions to queue up by the microphone because we're going to move to questions after this round of getting my questions answered.
So I agree with the professor. I think I also don't think this is as short a term an issue as the question suggests. Because if you go back to the Warren Court got withering criticism. And for years, and the dissents were visceral during that time. So there were a lot of issues made about Miranda, about school busing, about a host of issues back in the day where the court, I think, sort of, first took a tilt, or its ascendancy stopped, and it, took a slight hit down. I think now it seems to be a political strategy of both parties. When the Democrats controlled the court, the Republicans challenged its legitimacy. When the Republicans control the court, the Democrats challenge its legitimacy. I think challenging the legitimacy of institutions has become a political strategy that is not good long-term for America. It's just like criticizing the Constitution and failing to enforce the Constitution. Without the Constitution, we wouldn't have an institution like this where we can exchange ideas of this import openly. And it needs to be exercised from time to time, which is one of the things I think is most important about the professor. Recent law review article with Professor Paulson is, this is in the Constitution. This should happen, or it should at least be addressed. And I think we're getting there, thanks to efforts by Professor Taub and the institutions with whom she works.
Professor, quickly.
Yes. So I'm not a constitutional law scholar. I'm a business law person. But I notice when the Supreme Court intersects with my area of interest. And so I know what Professor Baude is saying when he's talking about balls and strikes. I think he's talking about other types of cases. But it's my observation that the Supreme Court actually does make law. I mean, one doctrine, the insider trading doctrine, does not exist in any statute. It was invented by the Supreme Court. I teach civil procedure, and there are lots of interpretations of what it means to have original jurisdiction in federal court. Nowhere in the Constitution, and the courts have interpreted it, and so on and so on and so on. And also, I think it's always been a political court. I think legitimacy depends upon stare decisis and the recognition that the court shouldn't be ahead of or behind the society. But it's always been a political court, entrenched in the values for good or ill of the society. Wait till you hear about Dred Scott. That was a really interesting case.
Mm-hmm. No polling during Dred Scott, though, so I would say that I've looked at long trajectories of polling, and I think there is a confidence gap right now for the Supreme Court. And when you have that in every other American institution, that presents a challenge with the public. So we're going to turn to questions from the audience. Go ahead.
Hello, my name is Anand. I'm from first year MPP from Harris School. I have this question to the panelists that when we talk about President Trump, I mean, we also see the rise of such kind of leadership spanning across the world, where there are fundamental questions, there are fundamental issues being tackled by the democratic processes around the world. I was wondering to ask you that what led to such leadership coming to the first place, and such leaderships having a strong legitimacy and acceptance in the popular imagination of common people? What is not addressed, what is actually ignored, what is actually excluded in our socio-political, historical identities, where end up creating this big effects and rounding up ultimately into such man rising to the power?
Yeah.
Thank you.
Who wants to take that one?
Well, I'll take the first shot, which is if you have time for lunch and dinner, I'd be happy to give you my view on that. I think this is a worldwide phenomenon. In Brazil recently, they had to choose between the gentleman who operated the largest corruption exercise in the history of the world, Operation Car Wash, and his successor, who is now in jail. The rise of sort of unusual candidates for leadership is something that's not just, we're not just encountering it here. Historically here, somebody, was an Eagle Scout, went to an Ivy League college, got a higher degree, and did a lot of service jobs and political service, before being qualified for president. Obviously, Trump didn't fit that mold. It was precisely because he didn't fit that mold that he got elected. People were fed up with the results that they were seeing, joblessness, losing jobs, international trade issues of consequence, the world becoming increasingly unsafe. So there were a lot of factors that led to Trump's election. I think one of the issues now is how is it that America is about to make a choice between these two candidates again, because that really does seem at 30,000 feet somewhat ridiculous.
We're going to move on to the next question.
Hello, I'm Pavlik. I'm second year at the University of Chicago. So currently, from what you're describing, there seems to be this sort of collision course of two things. One, from the things you have said, it seems highly likely that former President Trump will be convicted and imprisoned, and very this seems to be a very likely path. And at the same time, he seems to be the prospective nominee for the Republican Party and potentially becoming president. Legally speaking, I understand that that is possible for someone to get elected from prison. However, what are the sort of internal political / legal consequences of such an occurrence?
I think the question is, how is it that somebody who is convicted of a felony can become president of the United States?
There's some historical precedent for someone running for the presidency from prison. That would be Eugene Debs, but that goes way back. And but we have never seen someone be, in prison. As Ty said, the reality is, if we're talking about a federal conviction, that will that's going to go away if he is elected. And in terms of the state, that RICO case may take quite a while, and we just don't know how that will play out as a legal matter, whether the case will be allowed to continue. And even keep in mind, even if Georgia insists on moving forward, what happens? There's the real reality of what happens if, Donald Trump, if he's president, says, "I'm not showing up to your forum. Good luck." Then what happens? So I think if he is elected, and if the Georgia case has not already been fully adjudicated to its end, I think that it will be ignored. And if he is somehow imprisoned in Georgia, as opposed to some kind of home confinement, I think that would end if he were elected, and he would somehow be allowed to serve from the White House. I honestly don't see these cases coming to a complete conclusion before the election is what I'm thinking right now. But, there's a strong chance that he will be president again, just like Grover Cleveland.
Ty wants to weigh in.
So I agree completely with what Jennifer is saying here. And, just so that nobody leaves here confused on this issue, Trump won't be in jail by the time that the election takes place or that the next president is invested. He'll still have an appeal. The 99% likelihood is he would be, because of the novel nature of these cases, he would be out on appeal pending the resolution of those appeals. So he's not going to run from jail.
Next question.
Hi, my name is Elizabeth. I'm a third-year undergrad in the college studying law, letters, and society. And my question was, since there are so many impending cases, which one do you think will have the most impact on the 2024 election? Whether because it's a state case and maybe it will be more accessible to the public, or because you think the results of the case, the decision might have the biggest impact?
I think this is one for everyone to answer.
Well, I'll start. So I don't think any of the criminal cases will have any noticeable effect on the 2024 election. I think obviously there's this thought that this will be the one, this will be the straw that broke the camel's back. This will be the moment that sort of the norms shatter. But I think people have been saying that for a very long time, and it hasn't happened yet. And I think, especially since, as Ty says, even if he's convicted of inciting insurrection in the District of Columbia, it'll be on appeal to the D.C. Circuit by the time the election happens, and he'll say, it's not true and it's going to be overturned and whatever. I don't think any of them will noticeably affect the election. I do think the state cases about the ballot will affect the election, in part because they don't. This is the thing that's controversial. They don't require all the voters to change their mind. If the Supreme Court of Minnesota and the Supreme Court of the United States say constitutionally the voters are not eligible to pick Donald Trump, just like they can't pick Barack Obama.
Yeah. And they don't require beyond a reasonable doubt standard,
right?
Which is a big factor. I had to show that I actually practiced law once upon a time. Ty, you want to take that one?
So I agree with Professor Baude on that, and I think the only thing that will have a significant impact of all the pending matters. The only thing that will have a significant impact on the election is the possibility of him, being removed from the ballot. I do think that in the D.C. case, the D.C. federal case, that people will learn things that they don't know, and they'll learn them from friends and former employees and colleagues of Trump in a way that will further expose him. I don't expect that, though, to sway the diehards that have supported him so far.
I completely agree with my fellow panelists that these cases in Minnesota and Michigan and Colorado matter, because if any of them result in the Secretary of State saying, okay, well, we lost in court, he's not going to be on the ballot for the primary, the cascading effect in terms of what the Republican Party will have to do next, what other states have statutes or have similar voters who want to get him off the ballot. Talk about chaos. And so that's what's exciting to me.
Next question.
Some defenders of Trump say there's no way to prove that Trump didn't really believe he won. There are many answers to that, but one of them could be to bring evidence that Trump has a pattern and practice of creating alternate realities based on some big lie. And a very specific example might be the question of Trump's relation to Russia, that Trump and the Trumpists say this was a conspiracy of the Hillary Clinton campaign to fabricate this. But congressional committees never were, or the Supreme Court prevented congressional committees from obtaining facts about whether or why Deutsche Bank loaned Trump, for example, $650 million to build the Trump Tower downtown here when he already had defaulted on many loans. And so one speculation is that these loans were guaranteed by Russia. So would demonstrating a pattern of practice of creating a deliberate fabrication be grounds for subpoenaing facts about other lies that Trump concocted? And at a bigger picture,
we need a question.
What important function of the legal process is to bring facts to light. So how would that, or is it possible that that could fit into either the January 6th or Georgia presenting of the case?
Yeah, Jennifer.
So that's a complicated question that touches on things like the federal rules of evidence and so on. But let's say that there's enough. I mean, that is what they would be trying to do, but within the confines of the limitations of the case and controversy brought before the court.
Any other comment?
I guess I'll add. So I think almost all the cases don't actually have "I thought the election was stolen" defense. So the documents case in Florida, for instance, it just has nothing to do with whether or not Trump really won the election. Even if either way, you're not supposed to repeatedly obstruct the attempt to collect the classified documents back. Similarly, the insurrection clause of the 14th Amendment doesn't turn on whether you thought the insurrection was lawful. A lot of the people who waged the Civil War thought they were perfectly within their constitutional rights because they had a states' rights theory of the Constitution. They honestly did. They weren't lying. That was what they thought. But it didn't matter because they did not actually have that right. And even the charges brought by Jack Smith in D.C., the sort of fraud charges, a lot of them turn on fraud, not just the big lie, but the little lie. Like, so the fake electors, apart from who really won the election, you can't sign a document that says we met in the Michigan State House on this date if in fact the doors were locked and you were not allowed in the Michigan State House because you were the fake electors, not the real electors.
Yeah, that's an interesting point about the fake electors, which doesn't involve Trump directly, but indirectly, clearly tells the story of January 6th. Ty?
Yeah, I would only add one thing, which is, interestingly, as Professor Baude said, it really is irrelevant whether he thought he won, because the standard is knew or should have known, and there are about 70 federal officials who told him that he lost and he needed to walk away, including the Attorney General and everybody in the White House counsel's office. So I don't think that's a big hurdle for Jack Smith, even if that was an element.
And let me just say, although I agree with you, just for the sake of argument, for the case involving the insurrection, because those charges are under 1512, 1519 with our obstruction, you still need a corrupt intent. And although there's no need to prove whether or not he, what he thought whether he won or he didn't win, it would actually maybe affect the jury in terms of them believing that the prosecution had met its burden of proof.
Next question.
Hi, yeah, you can hear me. My name is Prashanthi. I am a first-year MPP student at Harris. First of all, thank you very much for the discussion. I found it very interesting. So my question is around this part where somebody mentioned that at best we could hope for a return to normalcy in 20 years. But I wanted to further ask, what would normalcy in the American context exactly entail? And maybe a few more general points, if you'd like to elaborate.
Who wants to take that one?
So I think there are seeds of an answer in what the two professors have said here today. I think Professor Baude's point, particularly about the fact that America, this is unusual, this is intense, this is distracting, and it's exhausting. But being a republic and protecting a republic is all those things. And the Constitution, is going to be defended, today, tomorrow, as long as we continue to exist as a republic. And there will be consequential issues like the ones we're discussing. So when you get back to normalcy, I mean, there's still going to be intense moments. I mean, America's going to, with the advent of AI, with the increased technological deficit that we're seeing between the U.S. and China, there are going to be a host of very serious issues that this country has to face in the upcoming years. So, I think normal is what the founders contemplated when they assumed that people would pull together and, as a united group of states and a united electorate, try to put America's interests first. Getting back to that is going to require the cooperation of many actors who I think are, being a little pouty these days, including the media, including our leaders, including President Trump.
I'm going to take the moderator's prerogative. Never before have I seen more people concerned about the democracy. And the good news is that the bad news is democracy is, as we see it, maybe under threat as it's never been before since the Civil War. But the good news is now everybody's not taking it for granted. Now we realize that as citizens, we all have an incredible obligation to exercise our voting franchise, to speak to our neighbors, to begin that dialogue about what a democracy means to us. And so when the citizens engage, it's not just going to be politicians and experts and lawyers who determine the future of our democracy. It's going to be the American people. And so we are going through a time when the American democracy is having a dialogue that we've not had in my lifetime. So that's the good news. Go ahead.
I think so. This also picks up something Ty said earlier. I think one of the features of the current crisis is that every substantive disagreement now has to also be a disagreement with the legitimacy of the institution and about your opponents. It's the tendency to level up every disagreement. So we're not just arguing about what should we do about the economy, or how do we handle crime, or how do we handle whatever, China, but we're also arguing about whether everybody who has the opposite view is corrupt in the pocket of big money, or corrupted by this, or influenced by that. So I think what it might look like is just we'll have lots of the first kind of dispute. Those would not go away. There are problems like that we need to be tackling more. But it's hopefully to spend more time on the object level dispute, sort of to keep our eye on the ball, so to speak, rather than to spend all of our time on secondary disputes where not only do we disagree about China, but we disagree about the legitimacy of anybody even discussing it.
Yeah, and I'll just quickly, what I would say is it's not like a math problem where there'd be like reversion to the mean. It's not, in the absence of people being actively engaged in democracy and being concerned and having dialogue about the issues that matter to us, whether it's shared prosperity or climate change or or crime, whatever the issues are. It's not like if this went away and we did nothing, that would happen. We've seen throughout history big sweeps of history, whether it's feudalism or the resurgence of autocracy or anything that we've had. We only, Benjamin Franklin says it, we know it, that we only get this republic if we work to keep it. So I don't know. I think I move away from the word normal toward a deliberate decision to engage in the very hard slog of different interest groups debating about what's going to happen and not making everyone who doesn't agree with you evil and not grinding government to a halt because you don't get everything you want, and being able to have friends on either side of the aisle. We're not there now because we have a quadruply indicted, adjudicated rapist who will do anything to hold on to power, who is the leader of the Republican Party. And even though that might not be all Republicans who support him, that creates a time now. We are abnormal now. I don't know that there's anything normal, but I'm hopeful that in 20 years, hopefully or less, things will feel like this is all of our democracy and we can get in the mix and debate the issues and not attack each other.
Thank you. Next question.
Thank you.
Hi there. My name's Matt. I'm a lawyer from New Zealand and just studying my master's here at the law school. Firstly, thank you. This has been fascinating so far. I just had a question on the point it's been discussed throughout around the American system running off norms and conventions that aren't challenged until they all of a sudden are, and you have to figure out how to deal with them. On one hand, a strong one that's been coming through is the idea that no one's above the rule of law, and I was just wondering if any of you have any thoughts around the tension with that ideal against, say, perhaps on the other side of the ledger that an election is a time period where you have a free election, a pure democracy, and the judiciary isn't used or perceived to be used as a weapon to interfere in that process. And at what point, not that, say for instance, we take the idea that Trump is guilty of all of these charges. At what point do you feel uneasy that there's a perception that the judiciary is used to interfere with your elections and there's consequences down the line to your actual democracy in future if that precedent is set? I think that's my question, but I'll leave it at that.
This is going to be our final question. It's a great one to end on. Jennifer, you want to take that first?
Yeah, I'm not as worried as you are because I can sometimes compartmentalize. And when I look at the states, I look at it as I see the statutes, and it's the obligation of the state secretaries of state to decide who can legitimately be on the ballot. So to me, it's kind of calling balls and strikes in that way.
So I am perpetually concerned about that perception. I think that's a very important thing because we don't want to become, a third world so-called democracy where leaders are jailed for their views. On the other hand, that as a line that I used in every trial, which is the only way for evil to prevail is for good people to do nothing. We're there. There is evil out there. There has been great injustice and great insult done to the Constitution. There have been some incredible, unprecedented acts that need to be adjudicated. I believe that failure to do that does less to protect the country than letting the country operate in a way where the institutions can defend themselves.
Yeah, I too lie awake at night worrying about this. I mean, there is a way in which it's the answer to one of the previous questions of how can you have, an elected president, who's in jail. The answer is the American people are more powerful than the American prosecutor. If they, they'll be heard. At the same time, I think there is always law underlying this election system. It's happened before. It's happened twice that somebody has become president not because they won the majority vote, but because they won the Electoral College, a special legal rule that says even the person who doesn't win the most votes gets to be president because of the rules of the game. And this also is one of the rules of the game. So if we're going to expect people to accept that even though my candidate won more votes, they don't get to be president because the Constitution says it's the Electoral College, it's only fair to also ask them to accept other things in the Constitution as well. But I think the underlying gut instinct I have is sort of like, in a well-functioning democracy, this panel would not be happening. It would be nice if we had a well-functioning democracy again, but we can't just pretend that we do.
Well, I want to thank everyone for coming out, especially you folks who have been sitting in the sun. Sorry about that, but let's have a wonderful round of applause to our wonderful panelists. Thank you for coming out. And remember, only you can defend democracy.